Welcome to the Transportation Risk Specialist Truck Stop webinar presented every second Thursday at 2 p.m. Eastern Standard Time. These webinars are presented as industry updates for information purposes only and do not qualify for state CE credit. If you're seeking state CE credit, email our office at Transportation Risk Specialist, TRS, at ivci.net, and we will send you information for these continuing education opportunities. If you have any questions, please type them in the chat window during the presentation. They'll be answered as time allows or responded to after the webinar by email. If you experience any audio problems, please send us a note in the chat window or call our office at 800-741-4084. We will attempt to correct the problems as soon as possible. Food Safety Modernization Act, FSMA. Hopefully you all have heard of this. For the next hour or so, we're going to discuss the ramifications of this act on our insureds and on insurance coverage. Who promulgated this act? Usually we deal with FMCSA and the DOT. This is not an FMCSA rule. It's a Food and Drug Administration rule. It's dealing with the cargo itself and how our insureds have to deal with that cargo, not any regulations like we deal with like speed limiters or electronic logs or hours of service. So this is another division of the government that is imposing this upon our insureds, even though we now, since it affects our insureds and their insurance coverage, we have to deal with it. As most of you know, my father was a trucker. He had a business rule not to haul watermelons. Why? Because if you did not get them delivered on July the 3rd, they were not the same value to the receiver on July the 5th. So the receiver would reject the load. And this is the problem we have here. A lot of the food that our insurers are hauling is driven by a market value at a place of delivery. If the market has gone down during the transportation, the receiver might not want to or need the product, so they'll reject it for about any reason they can. The question I'm going to ask the lawyers that we have involved today, the experts we have involved today, will this act give the receivers additional grounds to reject the loads? So if so, what can a motor carrier do when a load is rejected for any reason, particularly now the Food Safety Modernization Act? January 9, 2017, Transport Topics had an article with the April compliance date. This is important why this is timely, because now we're dealing with this in March. It's going to be effective next day. Approaching regulations are preparing to clamp down on bad actors in the food chain. And that bad actor can be a number of people here, but more interest to us as our motor carrier as they get involved in the transportation of these food grade products. Several industry experts agree that many businesses have been slow to prepare. So one of the things we hope we encourage you to do is prepare your insureds for this upcoming act and their place in it. The article goes on, says transportation industry remains pretty clueless about the rule, which will force shippers and carriers to have heart-to-heart conversations leading to these new controls. How many of your insureds who are hauling food-grade products have dealt with their customers, their shippers, in the last period of time and said, what additional requirements are you going to impose upon us because of this new act? If not, that's the starting point. The company relationship between the shipper and the motor carrier, our insurer, is about to become strained in some cases because now you have this overlying act and your insurer is going to have different additional responsibilities, and they're going to be pretty much at the mercy of the shipper or the receiver as far as how they're going to have those acts interpreted. So again, as we talk often, our most valuable relationship, our most valuable claim are cargo claims because they're dealing with our insurer's customers. And if the customer is not happy, then there could be some problems on their future business relationship. And this is one of the things that are now facing us that might be a part of those problems. This act is 283 pages, rules. And so you can go read if you want to and have nothing else to do. So we're going to try to summarize it here in this short period of time we have with you. The rule places the primary burden on shippers to ensure that the proper written procedure, keyword there's written procedure, and data collection, meaning records during transportation, are in place to keep the food properly cooled and trailer clean. Shippers are using the rules to add requirements in the carrier's contract, the motor carrier's contract, the shipper carrier contract. And this is where this will start. What are those new rules, and are you insured? And you need to ask them this. Have they signed any new contracts lately? And if so, what are those provisions? That the new regulation may be actually addressed. So what the shippers, if they're aware of this act, should be modifying their contracts with their motor carriers to build in the requirements that the shipper is placing on the motor carrier. Why is that important? Because now it's spelled out. At least now we have a roadmap on what the shipper expects the motor carrier to do. One of the problems we have there is that your insured might have many customers and many shippers. And unfortunately, each one of those contracts could have different provisions in it. So there will be a baseline that everybody needs to be aware of to meet the basic rules of the Act, but there could be some other wrinkles in this shipper contract. So your insurers need to be aware that they need to not only understand this Act, be compliant with this Act, but also how the shipper carrier contract might modify or add additional requirements to the Act. Carriers to be knowledgeable about the rules so they can avoid taking on greater responsibility. And if there are things in the contract that are greater, now you would want to encourage your insurer to address those, and if they can't, hire a lawyer like we're going to talk about today to help them address those things. But again, most of our motor carriers need the shippers to be that's their business source. So that becomes, again, as we said on the slide before, a controversial position between the two. If you provide insurance to motor carriers that haul food products, you need to understand the new rule. You need to see if your insurers are prepared and have signed new contracts that place additional responsibility on them for the care of these goods, so that when we write an insurance policy, we'll know how it will react to any of these claims. You also need to talk to your insurance company about how their policy will address a claim when the load gets rejected because of a violation of the Act, but no direct damage to the cargo. Most of the cargo policy says there has to be direct damage. We're talking now about product being rejected, shipper not, receiver not accepting it, not because they can show that there's mold on the item or that the carton is crushed, but because of the change in temperature, even though it doesn't look impaired. How will the coverage address the total loss being rejected and the shipper if the shipper controls salvage? So even the undamaged part has to be destroyed. So now we turn a partial load into a complete load because we cannot verify that the food goods can be consumed by other people, so the whole load has to be rejected. Does the cargo policy have a duty to defend in case of a dispute or court case? Over half the policies that I review on behalf of teaching and other things do not have a duty to defend. They have an option to defend. So in a lot of cases, your insured might have to bear the duty to defend that we don't owe it, and the insurance company might or might not defend them or fight that battle or pay the legal fees. Better insurers and shipper customer, that's what we need to deal with in their relationship. How does the policy address spoilage, contamination, mechanical breakdown? Again, and how does the duty to defend work? These are things you need to look at your insurance carrier coverages that you're providing in cargo to make sure that they, or at least how those individual carriers are going to address this claim. I've been in seminars presented by some cargo carriers, and one of the speakers said there's probably not going to be much difference in it because of this act. Another one says there's going to be a major difference in it because of this act. So we need to find out on the individual policies that you're delivering how they're going to react to the circumstances we're going to bring up today. Again, basically when the load gets rejected because of a violation of the this act. I asked Bridgette to join us here. Later we're going to have our friend Hank Sutton joining us. She's been a part of our webinar. She works for Jay Taylor. For you who have been at the annual conference, you've had the privilege of hearing her and putting on programs. And one of the things that we're going to do today is, we've already done today, is talk about her participation in the annual conference coming up. You'll hear more about it. If you need more information, or please refer your insureds to her to get more detail on this stuff. She's made an agreement with me, like a lot of the lawyers. She won't charge for a phone call only when she starts doing work and puts something in writing. Bridgette, say hello to everybody.
Good afternoon, Tommy. It's a pleasure to be here. Thank you for having me.
All right, let's go ahead and look at the act then, Bridgette. You want to explain this to them then, please?
Sure. So the Food Safety Modernization Act has been passed, and now we have various compliance deadlines that are coming into effect. So what we're seeing is shippers in particular that are starting to modify their operations. And so the Food Safety Modernization Act rule on sanitary transportation, human and animal food is now final.
Animal food too? Things are going to horses and pigs? So it's not only human consumption, it's animals also. Wow.
Well, so, and we're going to talk a little bit more about its applicability and those individuals that are going to be subject to the Act. So it's now advancing the FDA's effort to protect food from farm to table, farm to fork, so to speak, by keeping them safe from contamination during transportation. So this rule establishes requirements for shippers, receivers, loaders, but not necessarily unloaders, and we'll talk about that, carriers by motor or rail vehicle to use sanitary practices to ensure the safety of that food. So with some exception, the final rule applies to shippers, receivers, loaders, and carriers engaged in transportation operations, whether or not the food is offered for or enters interstate commerce. So that's important because a lot of us are familiar with talking about the applicability of the Carmack Amendment, and that being applicable to movements by motor carriers operating in interstate commerce, where shipments being subject to interstate commerce.
Remembering back to the Carmack Amendment, though, most of the stuff we're talking about here, food goods, if they're raw, the Carmack Amendment wouldn't apply anyway, would it not?
It's going to depend on whether it's an exempt commodity.
Exempt commodity, and the food, most of the food consumption of food would be exempt in most cases. So even so, we're dealing.
Unless there's a contract with the carrier that would establish otherwise, where they can impose the
Carmack Amendment. So what we're saying is Carmack Amendment itself would not be a conflict because in most of the cases, because the stuff that we're talking about here would be exempt from the Carmack. However, the shipper could impose the Carmack even on exempt commodities or modify the Carmack even if the Carmack applies with this act built in. That's a good point. Thank you.
Right, right. So one thing to note here too is that the definition of shipper has been expanded to mean the manufacturer or a freight broker who arranges for the transportation of food in the United States by a carrier or multiple carriers sequentially.
So if your insurer gets a load from if our insurer gets a load from a broker, then that, and it has to do with fresh fruits and vegetables and food items here, that later we'll define what's not covered, but basically stuff covered under this act, then that broker would have imposed liability or considerations on it, as well as the shipper then, because you could have two people involved in that one shipment and have possibly two sets of standards, correct?
Well, what you might find is that the shippers will delegate, and we'll talk about this contractual obligation that can be delegated downstream to the motor carriers. And so you could have a shipper customer that enters into a shipper agreement wherein the requirements that the shipper is going to impose for safe food handling under, we'll call it FSMA for short,
FSMA, okay,
is now getting passed on to the broker, and the broker, the party being the person that's only responsible for arranging the transportation, is now going to have to modify their contracts with their motor carriers.
Broker carrier contract.
Exactly, to make sure that those contractual requirements that the shipper are imposing on the broker mirrors the broker carrier agreement that the freight broker is entering into. So now not only do we have to look at our direct contracts with our shippers, but we also have to be aware of what the brokers may be putting in their contracts that now their customers are imposing on them.
And a lot of brokers handle a lot of things. And so one load might be subject to it, and one load might not, and a lot of times you don't have a separate contract for every load you're hauling for a broker. You have a master contract with them. That will be an interesting deal.
And one of the things we always say is know what is in your contract, not just for FSMA, but for other reasons as well. Don't just sign those broker motor carrier agreements because it's a high volume contract. Know what contractual duties you're taking on.
Wow. And of course, my father being a trucker, I don't believe in this, but That's if the trucker can read, right? or takes time to read. Type A personality, I don't take time to read, and how many truckers can do. Again, I being the son of a trucker, I have a right to say a few jokes about truckers.
You can, start with those high volume contracts where you've got the most exposure from where you're getting the most work from those brokerage contracts. And start with those and work your way down the list.
And again, most of the stuff we're dealing with, and there are some exceptions like watermelons, but most of the stuff we're dealing with reefer operations. So that's, again, where we would start considering this stuff. So if you're insured, our reefer operations, typically those reefers are there to haul items that could be spoiled during transportation. A high percentage of those items could be or are food grade stuff. So discussing with our insureds, that's where I would think I would start. Would you not? That doesn't limit, because you can haul watermelons and tomatoes on a flatbed. We see them haul all the time, and it will extend to those too. But basically, I mean, that's where we would start, would be the food grade, the reefer operation. Reefer, by the way, is not illegal even in other places in California and Colorado. We're talking about the refrigeration units and the temperature control stuff.
Right. So we're going to walk through some of the sections of FSMA, and there's specific requirements that now are imposed on vehicles and transportation operations. There's record-keeping requirements, training, and then there's also a section that allows for waivers, so folks can submit waivers to the applicability of the FSMA. But we're not going to go into great detail in that, because that's going to be something more that a shipper might be more interested in. But I just mentioned it because there is a section devoted to individuals that are subject to this act being able to seek waivers. So let's talk about vehicles and transportation equipment. So there's a section devoted here to the design and maintenance of vehicles and transportation equipment to ensure that it does not cause the food that it transports to become unsafe. So if the container has holes in it, that might subject the food to outside temperatures when when the product has to be maintained. Or if the containers are used for transportation of non-food products, can they be cleaned and sanitized if the container is subsequently used to transport food products?
When Bridget talks about container, we're talking about trailers with or without wheels. And the container would be without wheels, trailer would be wheels here. So there could be a difference if your floor of the trailer is wood versus aluminum, because it'd be harder to clean the wood off of it to keep it from containing, from the products being dumped in it, versus the metal floor or the aluminum floors that would be easier to keep clean. Something as simple as that could be a concern. I'm sorry to interrupt you here, and they also must be capable of maintaining the temperature necessary for safe transportation of the food. You mean they got to turn the thermoking unit on and put the fuel in it and calibrate it? So that would be the other thing. So and this would require, even though we have some more large policies that do not have a spoilage exception in it or mechanical breakdown exception in it anymore, where you have to prove it was been maintained. But even if your policy doesn't require it to be a defense in this act, you must prove that your thermoking, and that's the common refrigeration unit on the front of the trailers, have been maintained at the required limit, and some records of what was hauled before and how the trailer was cleaned out.
Right, right. So there's a couple things here that this particular section looks at. And the first question is, what is the intended use of that trailer or that container? And is it sufficient that the equipment is maintained to prevent food from becoming unsafe during transportation operations? So first, your insurers have to know, what are they transporting? And then the other provision then is, okay, if we're transporting food products, and they have to be temperature maintained, do we have the equipment that's going to be sufficient to provide adequate temperature control to prevent the food from becoming unsafe during transportation operations?
And record those temperatures, I assume, that part of it also, to make sure that they're doing it. That would be the proof later.
Right. So here, there's going to be other conditions that we're going to talk about where shippers have obligations in imposing temperature requirements. This particular section is just talking about the equipment itself and being of a design and having the capability to maintain temperature control. Also putting the obligation to ensure that the vehicles and transportation equipment are stored in a manner that it prevents it from harboring pests or becoming contaminated in any other manner that can result of food from being used or becoming unsafe during transportation.
Now, you mentioned a comment earlier. This is mainly imposed on the shipper to make sure that when a motor carrier are insured, the trucker comes to their yard to pick something up, that the equipment meets this standard part of it. Now, obviously, the motor carrier needs to make sure that their equipment meets this, but the burden here would be mainly on the shipper to make sure that the equipment is satisfactory.
Right. Now, keep in mind, we talked about that this section applies to shippers, receivers, loaders, and motor carriers. So this section talks about what requirements apply to vehicles and transportation equipment. So you have shippers that have their own equipment that are transporting food.
Well, a lot of times the shipper provides the trailers.
Right. Right. They can,
but the motor carrier might have a responsibility to make sure that trailer is adequate, even though the shipper provided it. Interesting deal. All right. I see why it could be a conflict.
Yes.
Okay.
But that's one facet of the subpart of FSMA, is just talking about making sure those vehicles have certain specifications to ensure that the food does not become unsafe during transportation. So then there's a section that talks about the transportation operations. And so transportation operations are all activities associated with food transportation that may affect the sanitary condition of food, which is including cleaning, inspection, maintenance, loading, and unloading, and operation of vehicles and transportation equipment. So this is just kind of touching about the scope of FSMA when it concerns transportation operations. So what are the things that we consider? Well, temperature control are one. We've talked about that. Preventing contamination of ready-to-eat food from touching raw food. So we're going to see that there's responsibilities that these affected persons, the shippers, receivers, loaders, and motor carriers, have when they are dealing with ready-to-eat food. Also, protection of food from contamination by non-food items in the same load or previous load. And we've certainly seen our fair share of cases where you have less than truckload shipments that may be carrying food items with non-food items.
So the LTL industry, the last mile delivery, the courier business would be affected by this in the gray area because, again, if they're hauling a mixed load, they might be hauling some things that are food goods and some things are not. All right.
Right. So let's say one question that came up is what happens if you restrict your carriers from transporting food items with non-food items, because the shipper may want to avoid the issue of will the non-food items contaminate the food items, and then do we shrink our pool of available motor carriers? And what's the solution behind that? Well, the solution from a shipper perspective is, well, we'll delegate that duty to the motor carrier to understand, can this non-food product be transported with the food product? So now all of a sudden you have the motor carrier wearing the hat of the shipper and making a pretty important decision as to whether or not that food's going to be safe for human consumption was transported with a non-food product.
So we can't haul batteries and bananas in the same trailer is what you're saying.
That's
okay.
right. So what is the it's going to come down to a very fact-specific question is, what does the FDA have to say about whether the food is, if it's properly shrink wrapped in a container, can it be transported with other non-food products? And if there's a specific, what is the chemical? Will the chemical expose it? If the chemical exposed to moisture in the truck, will that affect the food product?
All right, so we got to be careful about that, all right?
All right. And then protection from food from cross contact, and this is right out of the statute, the unintentional incorporation of a food allergen.
Right, it's something to contaminate it.
Then we have training requirements. So training of carrier personnel in sanitary transportation practices and documentation of the training. This training is required when the carrier and shipper agree that the carrier is responsible for sanitary conditions during transport.
Guys, a question that you have to ask all your insureds if they're hauling the food grade products, what have they done to train their drivers of the act? And a part of that training needs to be, and we talked about this at our classes, does that driver carry a thermometer with them? Do they know how, when they accept the load, do they know how to make sure the temperature of that load is what they're required to keep it at? And if so, how do they document the temperature they received it at, and also how they document the temperature they deliver it at? The driver training is a big part of this, and that would be one of our defenses if our insurers have properly trained the driver and they did all these things. It'd be one of the things that would cause us problems if they did not. So one of the things you need to ask your insurers almost immediately is, how well have you trained your drivers, not on this act, but anything have to do with the cargo handling documentation of the number of commodities there. Did the shipper load and count, or did the insured oversee the loading? What was the temperature of the items or the condition of the goods when they were put in there at the time? And so this would be something they would have to document and go through this. And right now there's no real protocol to this, is there not? It's probably up to however the trucker wants to do this, but there are some sources later, we'll talk about one with Hank, that might give them opportunity to train, to facilitate this training through a program that he has, and we'll talk about that at the end of the presentation. Hank, you still with us?
I am here.
Okay, see, I told you I'd refer you to this thing, so we'll get you to it then here, okay, buddy?
That's fine.
Go ahead.
Yeah, so what the statute says that when the carrier and the shipper have agreed to a written contract, the carrier is responsible in whole or in part for the sanitary conditions during transportation operations. The carrier must provide adequate training to personnel. You know, what is adequate, such that it provides awareness of potential food safety problems that may occur during food transportation, basic sanitary transportation practices to address those potential problems, and of the other responsibilities under the carrier. We've talked about this, shipper can delegate those. So the training must be provided upon hiring and as thereafter as needed. So if there was a claim, then that may be prompt a need for additional training. And then also there's an obligation of the carriers to maintain records documenting the training in this section, including specifically the date of the training, the type of the training, and the person or persons trained.
Big deal, particularly if you're a reefer operation, and particularly if your insurance has 75-80% turnover. This is going to require everybody there before they put them behind the wheel, not only meet the drug testing requirements and MBR requirements and things we go through, hiring a CDL driver, but also how they have been trained. So this needs to be added to the handbook and the training procedures and document, and again, suggesting, and that's the subject we can talk about later, have the drivers sign off that they've been trained in these things, just like we have an obligation to train them on the safety regs and rules, and everybody gives them one of those J.J. Keller green books to verify they've been trained.
Right. We see this in other contexts, but does the shipper also have an audit provision in the contract that says, we want to make sure that you're complying with our contractual requirements, and maybe once a year we have the right to audit what your training records are. So keep that in mind, whether those types of provisions may start appearing in contracts.
And so they'll come in and look at, quote, some private things you have in your business. Be interested. So the bottom line here is, what have your insureds done to train their drivers, not only as a part of this new act involving if they have a reefer operation?
Mm-hmm. Right. And then the question is, in the event of a claim, that it's going to be a fact question, what's adequate?
Right.
Unless you can get your shipper, which may be the most educated person with respect to the food handling requirements, to specifically delegate that. So to the extent possible, the motor carrier or the insured can shift that burden back to the carrier to say, we did exactly as was specified in our contract, or your port carrier controls it.
And again, we're going to talk about a service that Hank has put together to help motor carriers and our members to do this, and he'll talk briefly about this at the end of the presentation. Go ahead. We need to move on. Go ahead.
Sure, no problem. So there's also maintenance of records of written procedures, like we talked about, agreements and training required of carriers, and the required retention time for these records depends on the type of record and when the covered activity occurred, but not to exceed 12 months. Now keep in mind there may be other record keeping requirements from a DOT perspective, that just because one statute I would caution. Just because one statute gives the provision of a time limitation doesn't mean that may be the only record retention requirement that applies.
And if I remember, even typical Carmack, they got what? They got 9 months to file a claim after it's been delivered, and then 2 years and a day after that. I know that's being modified something, so the preservation of evidence in case it goes to court would be beyond the 12 months. But they need to have a regular getting rid of the records part of this here. Okay.
Right. So these written procedures that is referenced in this statute, now that the shippers will have their own record retention requirements, but our insureds will as well, and those are going to be reflecting what may have been delegated to them from their shippers. So in the event of a claim, let's say that you have a longer statute of limitations period and the shipper may come back and say, well, you breached the contract, but if we have our records past that 12-month period to show we followed those procedures just as it was delegated to us, that would be helpful information in the event of a litigation. So just things to think about with record retention. So in keeping with the overarching food safety goal of FSMA, the rule now solely focuses on practices that create safety risks rather than on those that affect its quality, so don't necessarily make it dangerous to consume. So there are provisions in the Federal Food, Drug, and Cosmetic Act that covers spoilage and other forms of adulteration.
So this is just an adjunct to these acts too. This is more the mechanical temperature cleaning stuff, not the results of it being contaminated or not.
Correct,
okay.
Right. So including during transportation.
Right.
All right, so we talked about loaders. Loaders have been added as a covered party. A loader is a person who physically loads food onto a motor carrier or rail vehicle. For loading a food not completely enclosed by a container, the loader must determine that the transportation equipment is in appropriate sanitary condition. So do our insureds, do they load? And look for those contracts, because we've certainly seen those contracts where it specifically states driver is responsible for loading and counting, and if there is any issue with the condition of the equipment, to contact dispatch or to so that dispatch can contact the customer.
And in this case, if it's in the contract, they might outsource that to a lump or not. That just reminded me, one of my job in the junior year during college was I had the concession of loading all my father's trucks that were brokering at the farmer's market in Clinton, North Carolina. I mean, I would be subject to this act here now. Okay, I don't know if I could even do that, but that was one of the college things. I got paid for that, and I loaded some of our own, but I had the concession. I won't tell you how I got that concession, but anyway, we did that. So actually, the driver hired me to load the truck. And this kind of stuff I hadn't thought about in that area, but this could be this. So before loading of food requiring temperature control, again, the loader must determine each mechanical refrigeration storage compartment is adequately prepared, meaning that it's already been cooled before they start putting the product in. This is a big concern here. You can't turn the Thermo-King on as you're being loaded because it takes time for the inside of that trailer to get to the acceptable temperature. So there must be, again, a waiting time or could be there, okay?
Right, exactly. And for the insureds, again, knowing what may be in their contract
with
the shippers. So the final rule clarifies that the intended use of the vehicle or equipment that is transporting animal feed versus human food in the production stage of the food being transported, that is raw materials versus finished products, are relevant in determining the applicability of the sanitary transportation requirements.
Part of this, it was said that there's a difference in holding corn or corn flakes. Corn flakes, I think somebody referred to this as shelf ready, meaning if it's cans or cartons like corn flakes and this kind of stuff, this act doesn't pertain to it. And I think it was interesting there, they say we don't care about use by date because that doesn't have anything to do that doesn't have anything to do with the deterioration of the product itself. So when my granddaughter comes and cleans my refrigerator out because everything I have is old in there, we're not talking about use by date, we're talking about the actual contamination. So that's a big difference here. If your insureds are hauling packaged items, then it would not be, there wouldn't be required, even though you have to keep it at a possible temperature control part of it. Okay.
Right. And so one of the things the definition states is that food not completely enclosed by a container any food that is placed into a container in such a manner that it is partially open to the surrounding environment.
Container means a cardboard box and a can or things like that. We're not talking about the container, the carrying compartment, meaning the trailer or the container. We're talking about the individual packaging here.
Right, in such a manner that it's partially open to the surrounding environment. Examples of containers include open wood baskets or crates, like you just mentioned, an open cardboard box, a vented cardboard box with a top, or like a vented plastic bag. So let's talk about the requirements for temperature. So requirements for the use of a temperature indicating or recording device during transport have been replaced with a more flexible approach. Shipper and carrier could agree to a temperature monitoring mechanism for foods that require temperature controls for safety. So let's talk about the shipper's responsibility. So they've got the primary responsibility for determining the appropriate transportation operations. And now rests with the shippers, who may rely on contractual agreements to assign some of these responsibilities to other parties.
Other parties is your insurance guys. And ladies, this is what we're dealing with here. This is why you got to look at these contracts.
Right. So they can develop and implement these written procedures to ensure that equipment and vehicles are appropriate for their, the sanitary conditions and safe transportation of food. And it may not just be in the transportation agreement. The motor carrier may receive a packet from the shipper which has core carrier operational controls that the shipper will expect the motor carrier to comply with as well. So it may be something outside of the contract or that is incorporated in by reference.
The contract, or it could even be the bill of lading signed the day the trucker gets there too, could have some of these, okay.
Shippers of food transported in bulk must develop and implement written procedures to ensure that a previous cargo does not make food unsafe. We've certainly seen those cases. Not any shippers of food that require temperature control for safety must also develop and implement written procedures to ensure that food is transported under adequate temperature control.
That's back to the reapers.
So unsafe food. If a covered person or company at any point in the transportation chain becomes aware of a possible failure of temperature control or any other condition that might render a food unsafe, that food must not be sold or distributed until a determination of safety is made.
So even if we wouldn't say if the refrigeration unit breaks down before it gets there, then the immediate repair, then before it can be cranked back up and move down there, what this says is the load might need to be inspected to make sure it has not been contaminated just because the unit broke down.
Right. Yeah, and it's interesting, Tommy, because think about situations where shippers are under a time clock, right, that each minute or a day that passes is going to reduce the value in that food. So adding this requirement now that the food must not be sold or distributed until determination is made can put further delay in the shippers.
Make it less valuable, reject it, and they're not going to be tolerant of that. And again, depending on the packaging and all, until you get signed off, you might not have any salvage.
Right. So if the shipper rejects the shipment and now it's on the motor carrier to mitigate their damages, if this is applied to them, now they have to work within the confines of FSMA to get that determination that the food is safe before they can salvage that product.
So it's not only at the end delivery, but during the transportation. If there's a tick in the refrigeration unit, if it breaks down, if it runs out of fuel, or some of the temperature spikes there, then they need to do something now about it, or could possibly.
Before it's sold or distributed,
right.
So before it is released, that's distributed, they would have to meet this requirement. So let's talk about the key FSMA requirements that apply to truckers. They require downloadable temperature monitoring, and this is what we had just talked about. Provides that if a shipment may have been contaminated, it must be inspected before it can be turned over into the supply chain. It contemplates that driver will have formal food safety training. We talked about that. And that carriers can be required to have formal record-keeping duties if the shipper has delegated those duties.
But they should keep those anyway, don't they? Cover their own posture to make sure they did these first 4 points here.
Exactly. Yeah. Right.
I want to say one thing on the previous slide here. This might mean that some of our insureds with older reaper units might have to relook at those monitoring devices and download record devices and how they're doing those kind of things. Too might be something you have to look at. But I'll pull up at your dock, and you now say, for example, we had talked about lunch today. You told me it was going to be kept, the requirement says it's going to be kept at minus 10 degrees. And it gets, and we're talking about frozen things here, meat, not a cucumber. And it was received at 10 degrees. So now they reject it. So the recourse is, and they reject typically the whole load. So the option here is they need to the next step would be, whose responsibility, now the shipper rejected it, whose responsibility is it to prove that it can't be used? Wouldn't that fall back on the motor carrier to call an inspector and have it signed off on it, because they're going to have to dispute? Is that the dispute that you might have with the shipper?
Mm-hmm. Right. Well, let's go back to that previous slide here. Here, there was the possible failure of temperature control, but the question is, minus 10 degrees versus 10 degrees, does that compromise the food product? And so here, under this provision, before the motor carrier could go and mitigate their damages and salvage that product, they'd have to get a determination that the food was still safe before it could be sold or distributed under this regulation.
Because it violates the shipper's requirements, and they reject it. Now I've got to, as a motor carrier, to counter that rejection, I'm going to have to go out and get it inspected. This is what that slide says. And so I've got to have a chain of inspectors. Again, Hank's going to help us do a protocol of this here in a few minutes, because I think this is a big thing. I think what he is trying to develop will help all of us to have some way to take care of this. Am I right, Hank, in that part of it?
Yeah, an interesting thing under FSMA, though, is frozen food is not covered.
Oh, is it? Okay.
But with respect to covered food, clearly it would have to be inspected. I think that best practice.
So the minus 10 and 10 degrees are not, but milk in a container at difference in 38 degrees and 33 degrees could be then what we're talking about, right?
Yeah, it could be. Obviously, the shipper may put restrictions on you that says he can dump it at his own desire if it's out of temperature around. But right. I'm sure, Tommy, you could elucidate us on, there's a difference between ambient temperature in the trailer and the core temperature, and lots of times the fact that something may be at plus 10 certainly doesn't mean it isn't frozen solid.
Yeah, what we're talking about here is something that again, at our motor carrier classes too, talking about cargo, your driver's going to have to have a thermostat with them before they put it on the truck to make sure what temperature they receive it at, and note that if it's different than what's required. Mike, in our discussion about this, a shrink-wrapped container of frozen items are not going to have a 20-degree change in the core temperature just because the trailer was at 10 degrees, versus minus 10. So those are things we have to argue. But the question I have here, Bridgette, and Hank can go here, the cargo's sitting there. It's time sensitive. It can spoil just because of it time. The tomatoes get riper, or the bananas get riper, and now we got to go find an inspector to allow us even to salvage anything a part of it. It's what we're saying here, right?
Right.
Wow.
Well, so previously we were, just from a business perspective, we were on a time crunch just to try to mitigate our damages and sustain as minimal of a loss as possible from a motor carrier perspective. And now we've got
Tommy, it would be my opinion as a carrier rep that if you maintained it within temperature specs and you were 24 hours late in terms of delivering it, you wouldn't necessarily have a Sanitary Food Act problem. You might have a deterioration of value problem.
My point is, yeah, I agree with you, Hank, but what happens if it's 5 degrees different, then, and yet it's really not spoiled? That's the current here. And so the inspector will say it's okay to sell, which means we can salvage it, or the shipper will be forced to take it, right? Or part of the law.
The other thing, Tommy, that I think is really interesting here, most of us Bridgette and I usually deal with regulated commodities, and as you know, produce is a different world. You've got the old Red Book and Blue Book standards of what are the acceptable ranges of temperature for various items, you know, that's a matter of custom and usage that this discussion today doesn't even begin to touch.
Right. So it's okay to sell, but that means the shipper still might not receive it, but they have some salvage. If partial is okay and partial is not, then there's some salvage. But in some cases, unless they get it signed off in time, because it might sit there and spoil while they're getting an inspector, then you have turned a partial load or a load that could have some mitigation and salvaging into a total loss.
Right, right. And what happens if it's not frozen? I mean, can the motor carrier, the shipper, then go and blast freeze it? Does that then change the condition of the main product? And
back to coverage here, and this might be a legal situation, but most of these loads are not the $1 million loads or even $100,000 loads. Most of the loads of tomatoes or produce or things like this might have a value of $25,000 to $40,000. So how much legal fees are we going to add to that defending that it was rejected improperly for that low amount? That's something we're going to have to, our insurance carriers going to have to consider, and we're going to have to consider here. The motor carrier says, I should not reject it, it was clean and all that, but the shipper still doesn't take it. So now we've got this claim out here, and so how far are we going to take that in the court actions? Because I can't even call either one of you two up and without getting a couple $1,000 bill, and all of a sudden, how much is that worth? Let's win this battle here. So that's going to be something that our insurance carriers are going to have to face in this stuff. Not only how quick we can get the inspection, what do we do with the commodities while we're waiting for inspection, and then how to handle the results of the inspection. These are things that, unfortunately, this act is only coming. We don't have any court cases yet or rejection yet based on this act. There's plenty of it that you and Hank both deal with based on just the general handling of the product, food grade stuff here. But this is putting another case in it.
Right. You know, one of the questions that you asked at the start of the program was, how are the insurance companies going to handle a claim when now we have FSMA requirements in our contracts? And one of the common provisions that we see in these insurance policies is, was the carrier legally liable for the loss? And if you get any kind of, you see these declination letters, what's the analysis that the insurance company takes? They apply the Carmack Amendment and they say, well, the motor carrier was not legally liable for the loss because there was no proof of damage to the product. So if we apply, now we have, let's say, we have a situation where it was an insured. They had a contract with the shipper. The shipper in their contract says to the motor carrier, we want you to comply with the following food safety procedures when transporting this product. But the insured, in negotiating the contract, reincorporates back in the Carmack Amendment. So I could see a situation where the insurance carrier would say, notwithstanding whatever contractual obligations were imposed on the insured, that the Carmack Amendment still applies because that is what governs the liability of the carrier. And under the policy, if there was, let's say, no proof of damage because it was either a fractional temperature difference. Yeah,
I mean, because it doesn't say what. It doesn't say what. How many of our drivers, our insureds, understand what a 5-degree change in temperature might or might not do to what they're hauling? And if the shipper imposes that part of it, then the whole load is contaminated until we have it inspected, but yet it's not damaged as such, and then it deteriorates during the inspection. Yeah, it's going to be an interesting case coming down here. You guys are going, is this the lawyer's annuity fund that this law has started here and this stuff? Because you just have made, in my opinion, cargo claims for this type of a marketplace, which used to be easier to write because it's not a high theft item. You follow? So we take the high cost of cargo claims or the large thefts of large dollars. We're now talking about a low value item where you have a now damage that can be done because of this act and other things that create where there's no salvage, where we can't do anything with it. I mean, the comment I made is my father had an agreement with his insurance carrier he can handle all the salvage for cucumbers because he knew what to do with them because that's all he hauled. And so, but now you might not have the salvage, because how are they going to find an inspector in a town they're not used to, who doesn't already have a relationship with a shipper, and how they're going to get it down there in a period of time before the load itself, even though it's at the right temperature, is not usable anymore, just because these items perish or deteriorate. Let's go ahead, Bridgette. I think we've got enough of oh my gosh it's here, and a couple people are going to sell their business. They're not writing reefers anymore for cargo purposes, and I don't want to discourage that. Something we have to walk through.
I think so, and keep in mind that under the requirements under this part, it says when the carrier and shipper have a written agreement that the carrier is responsible for the sanitary conditions, then the carrier is responsible, and it goes through what the applicable functions are of the motor carrier, like maintaining the equipment and transportation, or providing operating temperature proof of operating temperature.
So there's some defense in it.
Right, offering a vehicle or transportation with auxiliary refrigeration units. So there's specific references that says, and this is the caveat, when the carrier and shipper have a written agreement. My issue and analysis in this is if the carrier can continue to get the CARMAC amendment to apply, then the CARMAC amendment would preempt, at least my argument would be from the insured perspective, any contractual agreement that has been inserted into the contract. So I don't know. Hey, you might have some thoughts on that.
There's two steps I want to cross the time. First thing is just to raise the duty to defend, which might or might not do. You just raise how much additional cost you're going to get. Look, one of the things for you who were in annual conference might remember Aaron Huck with CJJ Digest. He just wrote a good article last week concerning some contracts involved here, and his studies showed that some of these contracts are being rewritten now for the big motor carriers, and some of the truckers he was talking about were unaware of these things. That's worth you all going back and looking at that article he wrote. That we didn't have time to incorporate that in here, but it was a very good article. And again, for you at the annual conference, might remember Aaron's participation in that conference.
Tommy, the only thing that I would want to interject is that produce is an entirely different world from regulated commodities. CARMAC does not apply. Before you beat up on lawyers too bad, you need to know that there are very few lawyers that even play in that sandbox. Most of those cargo claims are resolved through arbitration or unilateral offset, and you're right, the amounts seldom lead to litigation.
The CARMAC can't. There could be an agreement. What Bridgette says, and what the next slide is, there could be an agreement to incorporate the CARMAC into a federal law. And this is what you have to watch. Again, we don't know what the contracts say, so we're trying to go through some things that might be. And your point is well made.
Another point that I'm making that I know you will second is there's a whole breed of cat called a truck broker who doesn't usually even deal with contracts.
Well, that's true too, but now this act actually makes them have to deal with it or have it delegated, so that adds another layer to it, we said before. Okay, go the page before that, Bridgette. We already talked about the CARMAC preempt here. And so, next one. So we have to watch here, and this is what the point Hank's made on the next slide, is that we've got to deal with where you get it, your insureds get it directly from the shipper, would have to, versus directly from the broker, and has the broker incorporated the shipper's requirements in their contract, or does the broker say you still have to deliver with a shipper's contract, and so the motor carrier then would have to go and find out what those shipper's contracts are, even though they really don't have a relationship with the shipper because they got the load from the broker. This is going to add another layer to this stuff. So you've got to deal with both of these contracts. One, if you have a direct relationship with the shipper, but the second one, if you get these loads to a broker, is the broker going to put the standards, or are they going to refer to the shipper standards? So then you, before you pick the load up, have to meet those shipper standards.
Right.
Okay, let's go with this, okay?
All right, so one of the things that we haven't touched on here is some of the exceptions, and these are notable. So shippers, receivers, or carriers engaged in food transportation operations that have less than $500,000 in average annual revenues.
That's about 4 trucks, people.
Transportation activities performed by farm, transportation of food that is transshipped through the United States to another country, transportation of food that is imported for future export and that is neither consumed or distributed in the United States, transportation of compressed food, gases, carbon dioxide, nitrogen, and so on, and food contact substances, transportation of human food byproducts transported for use as animal food without further processing.
So the big exception here is the farmer is not required to meet this until they give it to the trucker, and then they have to, okay?
Transportation of human food byproducts for use as animal food without further processing, that is those that are sold directly to farmers to be fed to livestock. These do not include byproducts that are transported to these facilities to be manufactured into feed or pet food. One of the things here that people joke because I don't eat pickles, because I saw so many cucumbers spoiled. All those went to the pig farmers at the odor as I was loading these trucks. So that was one of the problems here. And so we're talking about that went to the pig farms, and we don't have to worry about it because we're not transporting. All right. Right. Transportation of food that is completely enclosed by a container, except the food that requires temperature control for safety. Right. And then transportation of live food animals, except things like shellfish. Okay. What else we got here? I think that leads us in. Hank, a lot of things we do for the foundation is when we have something like this, as we got the broker's bond and we got the source, the chameleon carriers with those things here, we also factor in trying to get some solution. Hank, in the next few minutes, can you tell them what the project you're doing here and then trying to set up this protocol, please, sir?
Sure. We started about 2 years ago when FDA was considering its FSMA rules, and we worked with the refrigerated warehouse group and the ag haulers to try to develop a standard, because FDA in its wisdom said we don't know everything, we're going to leave a lot of this up to custom and usage. The problems that you and Bridgette have foreseen are obviously problems that have to be dealt with. We're seeing shippers and brokers trying to enforce radical different contract provisions in the name of FSMA, and there's great possible confusion and interruption, particularly in the spot market as it affects small carriers. You can imagine if 10 shippers all have different contract relations that they jam down on brokers, and then those brokers have to have a scope of work addendum on every shipment, where a small carrier has to meet different standards. You're going to have chaos, you're going to have disruption in the marketplace, and it's very simply a knee-jerk reaction that goes well beyond what these rules are all about. You know, some of us lived through 9/11, and the rules that got jammed down on motor carriers were draconian. So we really wanted to avoid that, and I'd like to talk quickly about the pros and cons of FSMA. If we establish a protocol that establishes the minimum requirements that FSMA imposes, it's not going to be a bad world for the small carrier. By a protocol, what we mean is a set of standards that any carrier can meet by signing an agreement that they warrant that they'll comply with FSMA, and we've added to it that we would make available to the shippers and brokers not only who's a member of the protocol, but also vet their insurance with a certificate of insurance. Tommy, can you advance the next slide?
Yes, please, Bridgette. Next slide. Thank you.
Okay, we see the possible benefits of FSMA to be cleaning up some real mischief that has existed in a shipper's assertion that if a shipment has a broken seal, or if there's any possibility that it could have been contaminated, whether by temperature or by act of a terrorist, it must be destroyed. FSMA makes clear that actually it can be inspected and put in the supply chain, and we think that's an important benefit of FSMA, and hopefully can be used by carriers to expand into non-FSMA items. I mean, we've had trashed loads of flour and all kinds of things, so we view the inspected as one of the benefits. We also viewed the temperature maintenance requirement as an idea whose time has come. Traditionally, carriers have gotten jammed under Carmack even for receiving it in good condition and delivering it damaged when the fault wasn't the carrier's. Maybe it was loaded hot. Maybe the doors were swung open in the hot Memphis sun and the back two skids melted. With proper temperature maintenance, which is a requirement of the protocol, and having that reefer information, we believe a carrier will be able to better demonstrate that a temperature variance wasn't within his control. Bridget, we get to the next one. So what we think is needed is a universal system for having rejected shipments inspected and certified as fit for human consumption. Part of the Blue Ribbon group that put together the protocol is looking at trying to find a way to establish certified third-party inspectors to deal with that tyranny of the immediate. When a load, particularly of produce, is rejected, it needs to be inspected and a determination needs to be made. We're also looking at a dispute resolution program, which I think would keep the damn lawyers out of it, as Tommy's saying, and allow for an intelligent resolution of these disputes. There's already a dispute resolution program for the Fruit and Vegetable Association, and we're kind of looking at that. But what we have been trying to develop in the short run, given the time that's imposed, is to develop some consensus about uniform standards and approved food safety awareness training. One of the requirements that goes in April for motor carriers having 27.5 million or greater in revenue is a food safety awareness training, and as part of the protocol we're going to have really, I think, top-notch programs that you can put your carriers through. Next slide, please, Bridget. And so that's what this Uniform Food Safety Protocol is all about. We've basically taken the delegable duties that Bridget has covered and placed them in what would be kind of a prototype contract. A carrier, whether he's governed by all aspects of FSMA or not, can sign it, which then would become hopefully the gold standard for shippers and brokers using small carriers, and the minimum requirements that Bridget has covered with respect to equipment operations, the pre-cooling, and the dealing with the delegable duties. Next slide. So the purpose is to establish minimum standards. It's to publish for qualification and vetting purposes a list of subscribing carriers together with insurance information. I guess as most folks know, particularly in the spot market, a lot of carriers are picked up to handle produce that runs on a seasonal basis. There are 39,000 small carriers, that's under 10 trucks in this industry, and we think the protocol will be particularly important for them to have equal access, because there'll be the obvious attempts by large carriers to say, well, we're FSMA qualified, what about Two Truck Charlie? And this should hopefully level the playing field. Next slide, Bridget. So the protocol works by warranting a training module in compliance with the 16 FSMA duties. Carriers provide confirmation of the warranty, their address, and the insurance, and a $100 a year fee. And the protocol publishes the credentials, license, and all for the insurance companies. So far, the program, as it's getting launched, is finding that some of the large brokers are recommending, if not actually requiring, their contracting carriers to be a part of the program, because we really don't have a bad system now. The times at which contamination of foodstuffs during transportation causes an outbreak of something are rare, if ever. I think it's just important that people be able to have the documentation that goes with this, and that small carriers get the updated reefer and have those documentations of material that is necessary. And if
and what I suggest, guys and ladies and guys who are on this call, you need to put your insurers in contact with Hank to have a set standard and protocol and some ability to go through these steps. So when they become a court case, you have some defense here is a very positive thing, and Hank's providing this for us and for members and for you to ensure these things. So you have his contact information. You all can download this PowerPoint as well as you have Bridgette's information to go further. We hope this gives you a discussion of for all your insurers who are hauling food grade stuff. There's a lot of publications going out now. I suggest you stay on top of it, but you need to find out if your insurers have signed any contract, what those contracts said, what their training is, and how your insurance carriers are going to react to these things. Hank, thank you. Bridgette, thank you. And for that, we're finished with this month's truck stop. We look forward to seeing you all next month.
Thanks, Tommy.
Thanks, Tommy.